What a day. From the government gutting a portion of their case against Diddy to both sides battling it out over the law before closing arguments, we're going to break down everything that happened in day 30 of the Sean Combs criminal trial right now. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. On the eve of closing arguments in the Sean Diddy Combs federal sex crimes trial, we had another interesting day, day 30, a day that started out with rumors and reporting that charges were dropped against Diddy. That is not accurate. That's not quite what happened. There's also this talk about a constitutional challenge. Both sides, the judge working out the final jury instructions for the jury. This is important. This is the law. This is the rules that will govern the jury's deliberations. Very important in a complicated case like this when you have charges of racketeering, conspiracy, sex trafficking, transportation to engage in prostitution. A lot of elements, a lot of factors, a lot of requirements to find Combs guilty of each charge. It's quite complex. It's a battle between both sides, what the language is going to be and what the language is that the jury will hear. And I think the jury will actually probably have to take some time during deliberations to even figure out what these jury instructions mean before they even start deciding the case. And again, we anticipate closings tomorrow, probably going to extend into Friday too. In fact, we learned a little bit more about that today too. Prosecutor Maureen Comey even said that the jury may end up not even starting their deliberations till next week, till Monday. But let's talk about what happened today. And for that, let me bring in Law&Crime's reporter Elizabeth Millner, who has been in that courtroom all day. For everybody who knows, we're recording this right now at like almost 8 o'clock at night. You have been in the courtroom all day. It's been a very, very tiring day, Elizabeth, but great to see you. I have to ask you about the beginning of the day. When we woke up, we found out the government filed this letter regarding jury instructions. And remember, to prove racketeering conspiracy, the government needs to prove at least two underlying predicate crimes, essentially. There's arson, there's forced labor, there's kidnapping, there's bribery, there's witness tampering, all to support this idea of there was a criminal enterprise and that Combs and others engaged in a pattern of racketeering activity, a pattern of illegal activity. But then we get this letter from the government, and it says, quote, the government has removed instructions from the charge related to attempted kidnapping under both California and New York law, attempted arson under California law, and aiding and abetting sex trafficking. The government is no longer planning to proceed on these theories of liability, so instructions are no longer necessary. So people might be thinking, oh my gosh, they dropped those underlying crimes, right? Problem is, if you go to the indictment, the latest indictment, for kidnapping and arson, it specifically lays out multiple theories under state law. So there's the actual crimes themselves. It's kidnapping and arson, but there's also conspiracy to commit arson, kidnapping. There's aiding and abetting kidnapping and arson. There's attempted kidnapping and arson. So my initial thought is maybe they're not getting rid of arson and kidnapping as a whole, but only those specific theories, meaning we're arguing Combs engaged in conspiracy to commit arson, but not attempted arson. And remember, this all relates to the testimony of Kid Cudi, Capricorn Clark, Cassie Ventura. That's what we talk about with kidnapping and arson. So, Elizabeth, did you hear anything today in court to provide any kind of clarity on whether arson or kidnapping are still part of this case?
Yeah, I was expecting to hear just something along the lines of that. And, you know, with the government and the defense going just so fast in their arguments, I was really thinking, oh my God, did I miss them talking about this? But I don't think they even really touched upon this issue when court began finally at 3:45 today, because initially it was going to start at 12, then it was going to start at 2, then it was going to start at 3. Then the defense needed a little more time to read some things through. So then it started at 3:45. And so just as far as, you know, because a lot of people have been like, oh my God, charges are dropped. Oh my God, this case is over. The government, like, it wasn't any of that. Because to your point, Jesse, the government said in their letter it was only applying to attempted kidnapping under California and New York law, attempted arson under California law, and aiding and abetting sex trafficking. But as far as just a big moment, as far as them going into maybe more layman's terms on just what this all meant, they didn't go into that, and it was kind of disappointing. I was hoping they would kind of speak more about that, but really they were just going over these proposed instructions one by one, page by page by page.
By the way, I got to say this. As you know, we are always writing a lot of sidebars here. We're researching, we're doing breaking news, and I am constantly on the run. And look, I get hungry. I'm human. It's not so easy to just grab something that's healthy, and that is why I'm happy we have Huel as our sponsor. It's spelled Huel, and their Black Edition, ready to drink. This is a total game changer. It is a complete meal in one bottle. 35 grams of protein, 27 vitamins and minerals, high fiber, low sugar, so you feel full, focused, ready for your day. There's no prep, there's no cleanup, just grab and go. And Huel's already sold over 500 million meals around the world. By the way, affordable. You can get everything you need in less than $5. And look how many flavors they have. Iced coffee, they got, look, strawberry banana, chocolate. So when I'm rushing to get Sidebar done, particularly in breaking news, I can just grab one of these bottles. Start saving time and money without compromising your nutrition today with this exclusive offer for new customers of 15% off plus a free gift using our exclusive code SIDEBAR at Huel.com. Please see our description for the terms and conditions. Skip the stress, not the nutrition. So, okay, look, we'll find out tomorrow. I still think arson, kidnapping are a big part of this case. They spend so much time talking about the firebombing of Kid Cudi's car, talking about whether Capricorn Clark was kidnapped in different instances, whether or not Cassie was kidnapped in the 2016 video. So I'm sure it's still part of it, but we'll see. Okay, there was a big delay in court. You talked about it. Did I hear this right? It had something to do about, what, a constitutional challenge? I mean, something was going on with the attorneys and the judge. Did you find any clarity about that?
Well, when we first got into court today around 3 o'clock, because initially we were all sat down and ready to go at 2 o'clock. Then we heard from the marshals and the bailiffs that, this is getting pushed now to 3. But initially what we did learn is that, the parties have agreed to the verdict form. But then the defense asked for just a little more time. Now, initially they wanted 30 minutes, and again, this being around 3 o'clock. So initially we thought, okay, they're going to start at 3:30. Then the defendant, that of course being Sean Combs, wanted just a little bit more time to review these documents. So they pushed it to 3:45. But as far as just what the defense wanted in terms of what document they wanted to read to just get more clarity, because, as more documents are coming in, as more objections are coming in, as we're getting towards the end of the trial, the defense just wanted to take an extra look and an extra careful look at the latest charging document. And so they took that time to do it. Then we came back at 3:45, and then we really started kind of getting into those jury instructions, just really, again, piece by piece by piece.
Let's get into it. So the first one that there seemed to be a lot of debate about, not surprising, one of the most complicated charges of this case, racketeering conspiracy. There are a number of different parts to this. What did they say? Did they come to a decision about what is conspiracy? What is a criminal agreement? What is a criminal enterprise? Some of the big highlights that you saw between the prosecution and the defense, and do we have any kind of answers as to what the jury is going to be instructed regarding the top charge in this case, the charge that carries up to life in prison?
Yeah, and it seems like because it comes with such a hefty penalty of the possibility of life in prison, right, Jesse, that they took so much time really just going through all the thorough details, especially as it pertains to count 1, that being racketeering conspiracy, aka RICO. So right off the bat, they get to page 13, and the government had an objection, because again, when I say page by page by page, they really took it page 1, does anyone have objections to, et cetera, et cetera, et cetera. So by the time they got to page 13, the government objected kind of to the end of the page when it came to the conspiracy instruction, because the government wanted a note about co-conspirators and how they might not have known, but they can still be a part of the conspiracy. Whereas the defense said in an argument that some of the co-conspirators, like Christina Quorum, like KK, didn't know what was going on. So the defense objected to that because they said that's not necessary. They say that the law requires a co-conspirator join the agreement. Shapiro, again, Alexander Shapiro making these arguments on behalf of the defense here. But she had said that the issue was the knowledge of the alleged conspiracy. So what ended up happening is the judge overruled the government's objection, and he said that further clarification can be addressed in closing arguments. So then the defense had an objection to that same page, but then a different line where the line was in reference to actions speak louder than words. And the defense says it makes it seem like circumstantial evidence is more important than direct evidence. And so the judge says that he will change the sentence in context of conspiracy actions may speak louder than words. So again, this is all about the language here, where they're just adding little things here and there where it doesn't seem either prejudicial to the defendant, or that way they can make it very simple for the jury to really kind of understand this. So even in terms of just adding that little word like may is going to be added to those jury instructions. But another thing thing that they were really kind of talking about was the fourth element of RICO, because the government is saying that, it's more accurate to talk about the agreement of affairs. And their proposal was that the elements reflect the defendant knowingly agreed with co-conspirators, knowingly and unknowingly. And the defense was like, well, that actually goes to the fourth element. And then the judge ended up overruling the government's objection because it says it kind of conflates with the first and fourth element of RICO. Truly, it was a lot of legalese that they were kind of spelling out there. And so even in terms of just, again, it seemed like most of their arguments, especially in the first part of court today, was really just about RICO and the co-conspirators. So the defense had an objection to a line that said that the person must be common to the group as a whole. And they were saying the government is conflating things, that the purpose has to be a common purpose. There's a lot of case law about the common purpose. Again, the defense making this argument. The judge said that the proposed language might confuse the jury and that common purpose could be a number of different things. And so Alexander Shapiro asked if this could be added. The purpose must be a common purpose and can't merely represent one individual's own self-interest. So they were just talking about adding, if not shared, as the group as a whole. And then the government's like, okay, well, I don't think this is an instruction that should be receiving. They don't agree with the case necessarily cited. The judge agreed that he wasn't going to add the language, so he ended up overruling the defense's objection. And so it seemed like for the most part, Jesse, that really it was kind of like, what did the co-conspirators know? What did the defendant know in terms of just were they committing these, alleged criminal acts knowingly or unknowingly, those types of things? Because they even talked about just the core group overall and how the government was saying the core included this chief of staff, the security. And then they kind of pointed to things like D-Rock as the security. And again, so really just kind of focusing on that core group of people and whether or not they're all co-conspirators and things of that sort.
Look, the prosecution wants it as broad as possible, right? Because that's the way that they can actually convict them. The defense wants it as specific as possible so that the prosecution can't meet the burden here. They can't meet the elements. And it's important when you talk about what's the common purpose here. Was it just to serve and benefit Diddy, or was there a different common purpose? Was it a larger common purpose? So the criminal agreement, the criminal enterprise, the common purpose, that's all one part of racketeering. Then I mentioned you have these underlying predicate crimes. I understand today that was a big point of discussion too, right? What about forced labor, maybe not arson, kidnapping, but forced labor, maybe bribery or tampering with a witness. Any highlights from what we should be thinking about in terms of the underlying predicate crimes the prosecution has to prove as part of RICO conspiracy?
Yeah, they definitely spent a lot of time mainly talking about obstruction too. So for example, on page 29 of these proposed jury instructions, the government said that they're not required to prove that there was an ongoing federal case or investigation. And they asked that that language be included in the jury instructions. And at first I was kind of a little confused about this argument. I was like, okay, what does this have to do with what? Because, when we're inside that courtroom, we're not seeing these pages on the exhibit screens and nothing like that. We're really just taking their word as in terms of just listening to their argument. So I kind of got where they were going with this, because the government was saying that they're not required to prove that the conspirator knew that there was an investigation. Then the defense kind of chimes in and they say that the defendant still has to know or still has to have something in mind. And then I kind of thought about it in just terms of the testimony. And I think it's kind of related a little bit to Mia, because remember when Mia was on the witness stand, she said after Cassie's lawsuit came out, that shortly afterwards, D-Rock had messaged her. And so I think they were kind of trying to say that maybe the defense was kind of trying to say that Diddy didn't know that there was a federal investigation going on at this time. And so this whole allegation of obstruction in terms of reaching out to Mia, maybe possibly getting, her, word of approval to go and talk about, whether or not that Cassie and Sean Combs had this toxic relationship or not, or even just the allegations that Mia had while she was on the witness stand talking about how she thought that there was kind of this insinuation that, money would be given to her if she were to, make a statement in favor of Sean Combs. And so that's when it kind of clicked to me. But then the government is like, okay, I think the nexus is about communicating with the federal officer. And so the judge says that he'll consider copying the language from the obstruction part into this particular part of the the jury instruction. Then when we kind of talk about forced labor, when they were talking about forced labor, the government objected to some lines just including that labor services include sexual services. And they kind of say it's supported by the R. Kelly decision. So the government says that they will argue that sexual labor falls under the statute. And they said that we need to make it clear to the jury that this is a different kind of labor and it falls within labor and services, where the defense says clearly sex trafficking can fall under forced labor. And they kind of pointed to their motion for acquittal argument that they had made just yesterday. And so the judge ended up overruling the government's objection because he said that the concern is that the jury may be confused that sexual services automatically count as laboring services. And so the government will have a chance to kind of argue about this during their summations, aka their closing arguments. And so there was kind of, just again, the legalese as far as the defense objecting to lines about difficult and compulsory. And they say it goes to mirror what the government argues, that the term labor is sufficient. You don't need to include specially. Again, they're really just kind of making sure that every single word is accurate and perfect for the jury to really kind of understand and really kind of digest it as they're getting all these really kind of like legal jargon, legal words in terms of the instructions that they're going to be eventually given before they are able to deliberate.
Yeah, and the forced labor, the sexual acts as part of forced labor is interesting when you think about Mia, right? Because Mia says that she was sexually assaulted as an assistant. So then you move on to sex trafficking. Sex trafficking by force, fraud, coercion. There are 2 counts, minimum 15 years in prison. That's the way that it was argued by the prosecution. And you have one for Cassie Ventura Fine, one for Jane. It was interesting because I was reading the filings last night going into this, and the prosecution made a number of interesting choices or recommendations for language, in terms of they basically wanted instructions that prior consensual sexual activity is not determinative of whether a victim was sex trafficked. Even if a victim receives compensation, this can still be sex trafficking. A completed commercial sex act is not required. My understanding is these kinds of things came up today, debated by both the prosecution and the defense. And wasn't there something about that the way the prosecution has pled this case, that is what triggered the 15-year minimum that could be on the table for Sean Combs if he's convicted? What was the back and forth regarding sex trafficking and the language that the jury will hear on that?
Well, there was a lot of back and forth with the sex trafficking. Maybe not as much as the RICO, but definitely still there were moments, especially the defense, getting kind of animated while they were making their arguments. And by they, I mean Alexandra Shapiro. But as far as counts 2 and 4 goes, and that again pertaining to sex trafficking involving alleged victim 1, Cassie Ventura, and alleged victim 2, that being Jane. And so the government really was talking at first when it comes to this charge just about how physical restraint is not required. And it kind of falls under the same, I guess, guise as forced labor. And so the judge ended up agreeing about this because I think a lot of people in their minds, when they think of sex trafficking, they may think of like physical restraint or that they were being held against their will, locked up in a basement or a warehouse, that type of thing. And so I think what the government is saying is that there needs to be an instruction that doesn't, or an instruction that includes that physical restraint is not a requirement to prove sex trafficking. Then the defense is saying that they were really kind of upset, I think, about the whole commercial sex acts kind of language that was used, because the defense argued that each of the 4 indictments, so that's the first indictment and the 3 superseding indictments that followed, according to the defense, they say that the victims engaged in commercial sex acts. And I mean, that was something that was laid out in the indictments. And so the defense argued that the government claims, and there are multiple enterprise letters, that there were multiple dates and places of commercial sex acts, whereas the government says they aren't bound to their enterprise letter. And they argued that not every commercial sex act was completed, but some were. And they wanted that particular language to be added because they kind of point to the escorts being told to leave, something that Jane had testified to. There were also, they brought up the 2016 Intercontinental Hotel incident where Cassie, is seen on that surveillance video. According to her testimony, she was leaving a freak off. And so they kind of count that as this is not a completed sex act. And so the court said that they asked the court to give this instruction, whereas the defense kind of thought it was a little prejudicial. They say that the attempt is already captured here, and they say that the government shouldn't be allowed to argue it's not a harboring offense. The defense says, I'm concerned if the language is included that the victims engaged in sex trafficking if sex didn't occur. And so she's getting a little, she being Alexandra Shapiro was getting kind of animated here because she was saying that it's not fair that she thought initially the judge was saying that they made a late objection and that they got this objection in a little too late. And then Alexandra Shapiro was like, this isn't fair that we're making a late objection. The judge says, I didn't say it was a late objection. And then he ended up saying that he'll end up considering the issue. So the government said in their argument that they don't plan on making a lengthy harboring claim. So it seems like it's something that's definitely going to be talked about during closing arguments. And then as far as just the whole kind of exchange as far as initial consent and whether or not just because an alleged victim initially consented to doing the hotel nights or the freak-offs, that it doesn't mean that sex trafficking didn't occur. And so the government thought that this kind of language would be a little confusing to the jury. The defense says that there should be language about the defendant and his knowledge because the victims initially, initially the defense says that, these alleged victims, they initially agreed to be doing these hotel nights and these freak-offs. And so in terms of just Sean Combs' state of mind, he didn't know, especially towards the end, that this might have been non-consensual or that the victims didn't want to participate because of that initial consent. So a lot of the sex trafficking, kind of the same with the RICO, where it's just like about language, but I think it goes a little bit deeper, especially because of that gray area that these women were Sean Combs' former girlfriends. And so I think from the defense's point of view, they were really trying to argue just as to Sean Combs' state of mind, what he knew, what he didn't know. And they were initially, they were pretty much arguing that Sean Combs, because the alleged victims had consented at the beginning, doesn't mean that he was in the know that even towards the end of their respective relationships that they no longer wanted to participate in these hotel nights / freak-offs.
And then we go to counts 3 and 5. Transportation to engage in prostitution, which I have said before, feels like the most straightforward path for conviction of Sean Combs. You talk about the hotel records, the transport the travel records, the payments, the text messages, the voice notes from Sean Combs, that he played allegedly an integral part in transporting these individuals and these alleged victims for the purposes of sex work. Forget force, fraud, and coercion. That's not a part of it. It feels like a straightforward case. So I imagined when it came to the language there, the defense would try to put in anything that was beneficial to them, right? What was the back and forth regarding the language of transportation to engage in prostitution, which, by the way, nobody sneezes at that charge. It's a prostitution charge, but it carries up to 10 years in prison. So what was the back and forth on the language there?
Well, Jesse, the argument didn't last as long as maybe the other arguments go in terms of RICO and sex trafficking. And even Alexandra Shapiro said, okay, once we get to the Mann Act charges, we'll go a little bit faster here because by this time it's close to 7 p.m. They even turned the air off in the courthouse, so it was getting a little toasty in there. But once we finally got to counts 3 and 5, then we kind of were really getting to the beginning of the end of these arguments. But initially, the government had the first objection where they said the whole would engage in prostitution. They wanted that specific language to be changed to an act of prostitution because they say they didn't want to imply that the person who was transported and in some instances across state lines was a sex worker. And so I think that they were trying to say that these were acts of prostitution, not that these escorts or entertainers were actual prostitutes, that they were just doing acts of prostitution. Again, because when they testified, that being Daniel Phillip and Sheree Hayes, something that the defense pointed out is that both of these men said that they weren't prostitutes. They say that what they were doing was being paid for time and experience. They weren't being paid or didn't think that they were being paid for prostitution. And so the judge ended up kind of siding with the government here. And so that specific language will be changed to acts of prostitution.
Yeah.
And so then the defense had some kind of issues a little bit with other lines that were included in this particular charge, but it seems like that was the biggest thing from both sides to really kind of hammer out here.
That's a problem for the defense because that was one of their arguments. They even made it yesterday during their Rule 29 motion. Hey, these people weren't, prostitutes. He was paying them for their time and experience. Well, now it doesn't matter. If you transported them and in the end, right, there was a commercial sex act, there was an act of prostitution, that's a big win for the prosecution right there. Real quick, before we just wrap things up on some of these finer points, would you say generally your view was the language is more beneficial to the prosecution at the end of the day than it was for the defense?
Well, I mean, that's a really good question. I feel like it could go either way because I'm just always thinking of it in layman's terms. You know, these are lawyers and very well experienced lawyers at that, where they may say, okay, this language is very clear cut. A jury will understand that. And jurors are very smart. That I will say that for sure. But in terms of just how this will all be read after hours and hours of closing arguments, I'm kind of wondering, okay, will this all click with the jury that this means this and this means that? But we'll have to wait and see what their reaction is once they ultimately sit down, get those closing arguments, and then get those instructions before they go into that room and deliberate.
And there was more parts that were debated between the attorneys and the judge. There was about language about what immunity is and what implicit bias is. There was also this thing about not having the G in government capitalized. The defense probably didn't want that. I don't know. Maybe it gives the government more authority. I don't know why they didn't really want that. That was interesting. But then right before they wrapped up court, there was this whole back and forth, right, between the prosecution and the defense about closing arguments. And when the defense's closing argument that's going to be delivered by Mark Agnifilo, when can he begin? What happened there?
Yeah, so it was kind of at that final moment. I think a lot of us were just antsy to get out of the courtroom. And then Alexandra Shapiro stands up. She's like, Your Honor, I have just one more thing. And so she actually asked the judge on behalf of Mark Agnifilo, he wasn't present during this particular hearing. However, his client, Sean Combs, was. But he wasn't here at this hearing mainly because he's preparing for closing arguments. Now, the ask was to move the defense's closings to Friday morning and begin on Friday. But what ended up happening is the government objected to this. They were like, I think this is just the defense kind of trying to play chess here, and that they were trying to get extra time to prepare for their closing arguments, and they don't want to waste the jury's time by only bringing them in for half a day. And so what they ended up doing is they're going to move closings just a little bit later tomorrow. I think they're going to start around maybe 10 o'clock-ish. They'll do 2 hours. We'll take a lunch break, and this will be the government first starting off. They'll do 2 hours of their summations. We'll have a lunch break. The government will finish their summations, and then likely the jury will be able to go home hopefully early in the afternoon. Then the defense will come back on Friday, do their summations, and the government will have about an hour for rebuttal, then the jury instructions, and then possibly deliberations might still begin on Friday. It seems like from both sides, they didn't want to waste the jury's time because especially with the 4th of July holiday coming up just next week, I think timing was really important to both sides. But it seems like from my understanding of everything that they are possibly prepared for deliberations to begin on Friday afternoon.
Yeah, look, the defense didn't want to begin their very important closing argument after lunch when the jury's tired after they already heard the prosecution's closing. They want them fresh. So I completely understand that. But at the end of the day, let's not forget, this is going to be, I imagine, a long deliberation process. But with the July 4th holiday, you also imagine the jurors want to get this done before that. But I don't know. Given the complexity of this case, don't be surprised if it extends past the July 4th holiday. Elizabeth Millner, I know it was a long day. Thank you so much. We got a long one tomorrow. Closing arguments begin and jury instructions. Thank you so much.
Thanks, Jesse.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.